Good afternoon, everyone.
Hello, Judge.
Hello, how are you?
Great.
Great for the day after. All right, is everybody here? I think
Your Honor, can you hear us in courtroom too?
I can.
All right, thank you.
All right, let me go ahead and start the calendar. Good afternoon, ladies and gentlemen. My name is Judge Yuri, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and these cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we're able to address several matters, including bond arraignment and possible plea offer if one has been made by the state at this juncture. I'm going to be providing individuals with a reset date. Looks like that reset date for SAP is December the 8th. That will be December the 8th. If you don't make bond, that will be the date your case will be heard again. I'm going to also begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. So govern yourselves accordingly. I want to also inform the defendants on this calendar that you have certain constitutional rights, one being the right to have counsel or representation with you at this juncture in your case. Most of you do and know who your attorneys are at this point. You also have a right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be held against you. The solicitors are here and they're listening, so listen to your attorneys. And again, govern yourselves accordingly. Who do we have first, deputies?
We have position number 10, Mr. Tirado, position number 10.
All right, this is case number 22 CR 007949G. Samuel Tirado, you're charged at 1 count of battery, 2nd count of criminal trespass. The offense date is November the 22nd, 2022. Pretrial?
He has a total of 16 cycles, 8 out of Florida, 6 out of Virginia, and 2 out of Georgia. His last arrest was May 26th of 2021 for assault and battery in Virginia. That case appears to be open. There's no disposition listed. His last felony conviction I'm showing is in 1999 out of Florida for escape. A 1998 conviction out of Florida for murder and armed robbery. And then a 1994 conviction out of Virginia for obstruction of private property, and nothing further.
All right. And is this Miss Gardner's case or Miss Harmon?
Good afternoon, Your Honor. It's Aaliyah Harmon for the state on this matter.
Yes.
All right. Your Honor, this is a recent physical dispute between himself and a woman named Michaela Lopez. She is also on the calendar. She was arrested as a cross defendant in this incident. On this day, Your Honor, there was a physical dispute in which the defendant caused bruising to the left side of the face of the victim. She did try to, when the dispute occurred, she did try to retreat to the bathroom. She locked herself in, and the defendant kicked the door in and broke the crown molding of the door in order to continue the physical assault. As you heard the history, Your Honor, it is very concerning, even though some of it is very remote. It is still violent history that concerns us. We do believe that he represents a flight risk. This is a multi-state offender. And with his violent history, we do believe that he represents a danger to the community, as well as a direct danger to the victim in this case. Our recommendation in light of those facts is on the battery charge, we're going to recommend a $5,000 cash bond, no further contact with the victim, Michaela Lopez, that's Micaela Lopez, common spelling. He is to have no alcohol, drugs, or weapons, a 1-day anger awareness, and we would ask that he would be not permitted to return to the incident location of 1315 Sandalwood Drive in Atlanta. On the criminal trespass, we're going to recommend a $1,000 surety bond with the same conditions. Nothing further from the state.
All right. Is this your
Good
case?
afternoon, Your Honor.
Good afternoon. How are you?
I am fine, thank you for asking. My client is 46 years old. He tells me he has 2 years of college. He is currently working, he is employed. He was actually the victim in this case, Your Honor. He was attacked by Miss Lopez. He had she burned him with a cigarette, and that was one of the reasons that that she was arrested. She was the one who attacked him. He was at his home. They do not live together, although they were in a relationship. They actually do not live together. This incident happened at his home. This is my understanding. And she was the one who attacked him. And she actually told him, she wanted them both to go to jail. And that is what ended up happening. So even though my client does have some history, as the prosecutor pointed out, most of his history is quite remote. And he was a victim here. So based on that, Your Honor, I would ask the court to give him a reasonable bond. A cash bond is not a reasonable bond in this case, given the facts as alleged, and also the fact that my client contends, and the facts seem to support that he perhaps was not the aggressor. She did, in fact, attack him. She may have retreated, but that doesn't mean that she was not the initial aggressor, Your Honor. My client was simply trying to defend himself against this attack in his own home. Based on that, Your Honor, I'd ask the court to give him a reasonable bond so he can get out of jail. And also, as to the stay away provision, this is his home and they do not live together. So there's absolutely no reason why he should have to stay away from his own home.
Your Honor, if that is in fact the defendant's home, then I will withdraw the stay away, but have no further contact with the victim. I do think in this case, a cash bond is reasonable. I am having a little bit of difficulty with Odyssey if pretrial can confirm, but I did see something in 2021, something called fugitive charge, as if he had some charges out of another state that he needs to address. And I do think that that does necessitate the cash bond. He does have criminal activity in multiple states, and I do think a cash bond is necessary to guarantee in some way his return to court.
Pretrial?
The only thing I see is the last arrest that I mentioned that may be open out of Virginia.
And what year was that you had for that pretrial? I'm sorry.
My client tells me that Virginia charge has already been dismissed. We discussed it.
And what year was that charge?
May 26, 2021.
Okay. Yes, Your Honor, I believe that's what I was referring to. I'm just trying to restart my Odyssey. Okay.
All right, is the victim on Zoom today at all? I
She
don't.
was arrested, Your Honor, for
Yes,
attacking my client.
Co-defendant. My bad, I'm sorry, she's a co-defendant.
And Your Honor, this is Allison Whitfield from the Public Defender. I was supposed to speak with Ms. Lopez. However, I never received a call from Union City. I have not spoken with her about this case, but considering they are cross defendants, we would just ask that Your Honor impose any reasonable bond conditions that are that Your Honor considers, that we defer to you.
I'm sorry, I think I said co in error, I meant cross defendant, apologize for that. Is Ms. Lopez going to be coming forward from the South Annex?
I am not aware.
She's on the calendar.
Your Honor, I know we're having internet issues, so they're trying to log on. I see that they're on, but they might not be fully on.
Mm-hmm.
We've been having issues all day.
Okay, let's see what we can do. If we can't hear it back to back, then, I'll take note of the facts of the case. And I was just seeing if we were able to do her case next, but let me go ahead and rule on Mr. Tirado's case. And then we'll see what we get from South Annex.
And again, Your Honor, I have not had a chance to speak with her yet, so I cannot present a full bond argument for you at this time, but
Oh, okay, Deputy, are you able to call over there to see if they can arrange for PD Whitfield to call in or to speak with Ms. Lopez by chance?
Yes, I'll give them a call, Your Honor.
Okay, thank you. And then we'll let you know, Ms. Whitfield, what we can do so that you can speak with her before we have the hearing, okay?
thank you, Your Honor.
Okay, all right. Let me go back, Mr. Tirado. So your attorney has stated that you live at this address 1315 Sandalwood Drive, is that correct?
Yes, ma'am.
Okay, and so the victim, Ms. Lopez, does not reside there with you?
No, ma'am. I was washing the clothes. Sir.
I'm sorry?
I said I was washing the clothes. Sir.
He's saying that she just came over to wash some clothes in your
Okay, okay, couldn't hear you well, sorry about that.
No problem.
Right, okay. All right, that's all I would ask. What I'm going to do is I'm going to order a surety bond And on the battery charge, I will order a $7,500 surety bond. And on the criminal trespass, the $1,000 surety bond. So that'll be a total of $8,500.
May I ask what is a surety bond? I
Your
don't know.
attorney will explain.
I
it
can
to you.
explain that to you. It's a surety bond is one where you can go to a bonds person to post your bond,
Okay, all right,
or you can put up some property.
okay.
All right. And I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order no further contact with Michaela Lopez.
No problem.
And I'm not going to do the stay away unless I have to come back and amend after we have Michaela Lopez's hearing. But with no further contact, if you were to go back to your home, she shouldn't be there. If she is, obviously you need to not go there because you would be violating your bond conditions. So I'm going to trust that that will be the case, but your attorney will let you know once we have her hearing, if there's any amendments that I may need to make to your bond order. But as of right now, I will allow you to go back as long as the victim, Ms. Lopez, is not residing there and obviously cannot come there. And you need to make sure of that as well so that you don't violate your bond conditions, okay?
Yes, ma'am.
All right, that should conclude this case. Anything else, counsel?
Thank you, Your Honor. No.
No, Your Honor.
All right, thank you.
Position 12 is next.
Okay. This is case number 22 CR 007947J. Is it Carmy Williams? And you're charged with one count of simple assault, the second count of willful obstruction of a law enforcement officer. That offense date is 11/24/2022. Pre-trial?
3 cycles. The last arrest was June 24th of 2021 for theft by conversion. That is an open case, 21 CP 200930. She has no convictions. She has a first offender for forgery out of Gwinnett that was sealed in 2017. And nothing further.
All right.
Yes, Your Honor, this is my case. This is a case where Miss Williams was spotted by security guards who were working in the area of 1050 White Street Southwest, where's their post, and she was driving a suspicious vehicle. The vehicle had part of its tag obscured. So security guards did follow her to kind of make sure they were keeping an eye on that vehicle. The defendant followed the security guard around the patrol and asked the security guard, Miss Samantha Davison, why she was being followed. And in the course of her conversation with Miss Davison, she brandished a firearm and waved it around and indicated to Miss Davison, I got one, I can show you. And then she further indicated that somebody was trying to kill her. And that's essentially the facts of the case. When she was stopped by officers, she did refuse to obey verbal commands to come out of the car when she was directly asked to do so. So that's the basis of the willful obstruction. She does have 3 cycles, as pre-trial mentioned. However, because this case involves a handgun, and there was really no reason for her to brandish that handgun, our recommendation in this case is a $4,000 surety bond, a stay away from that incident location of 1050 White Street Southwest, absolutely no alcohol, drugs, or weapons, and no further contact with Samantha Davison, who is the victim in this case. On the willful obstruction, we would recommend a $1,000 surety bond. We are concerned that she does have the open case, the theft by conversion. that does indicate that she may have a likelihood to reoffend. And I think she's a danger to the community because, again, and to the victim, there was no reason for her to brandish this gun. She wasn't, it was just nothing that is indicative in the facts that says she needed to brandish the gun. So that's our recommendation in this case.
All right, Ms. Williams, please put your hand down. It is not your time to speak. Your attorney will represent you accordingly. So hold on, please. All right, from the PD's office, Ms. Whitfield, okay.
Yes, Your Honor, thank you. Ms. Williams denies all of the allegations from the state. She indicates that she's told me that she denies brandishing a handgun. She is not a convicted felon. She has a right to own and possess a handgun. She was, I believe this all allegedly took place quite late at night, early in the morning. So she believes she needed her handgun with her at the time for protection. She did not, like I said, she denies brandishing it. She denies using it in any threatening way, and also would appreciate an opportunity to return to court once she is bonded out to challenge these as well. Ms. Williams is 34 years old, Your Honor. Her mother lives in the Atlanta area. She's lived in Atlanta all her life herself. She has an undergraduate degree in business administration, graduated cum laude. She also has an associate's degree. She has no reason to, I've spoken to her about being in contact with Ms. Davidson, the alleged victim in this case. They have no prior relationship, no reason to continue to contact each other. So we do not oppose a stay away. We do not oppose a no contact provision, Your Honor. We're asking for a signature bond in this case. I understand it involves a firearm. However, given Ms. Williams's lack of criminal history and particularly lack of any violent criminal history, her denial of these allegations, Your Honor, we're asking for that signature bond at this time.
Okay.
And Ms. Williams, I'm sorry, Your Honor, Ms. Williams still has her hand up. Do you have a question about bond? I would just remind you that you have a right not to incriminate yourself and to remain silent about the charges.
I know, but I would like to speak on my behalf.
Well, this is not your trial. This is just a bond.
I know. I'm not going to speak. I'm not going to speak about the case. I would like to speak on my behalf, please, Your Honor. Just allow me to speak.
Your attorney is going to cringe and not recommend that because you may say something against your.
I won't say something to incriminate myself because I'm not a criminal.
Your Honor, I've advised her on her Fifth Amendment rights to remain silent. If she wishes to speak at the court's discretion, then
I'll give you a few seconds against your attorney's wishes. If you start to go south, I'll stop you. What is it you would like to tell the court in considering a bond?
In consideration of a bond, I do not have the funds to pay for something that I did not do. And secondly, I went to the security guard to ask them for help, and I was
You're going too far.
I just can't afford anything but a signature bond, honestly. And that's all I have to say. Thank you.
She is unemployed, Your Honor.
Okay.
And Your Honor,
Again, she has a bachelor's degree and an associate's degree.
That's
Yeah.
correct.
I'm cum laude, top of my class. I'm in the newspaper, Georgia Southwestern State University, President Carter School. I'm very intellectual.
Well, if you're very intellectual, it sounds like you should have a job. And remember, with the surety bond, it's a 10 to 15% that your family or whomever.
Oh,
would
well, I don't have money right now. You don't know, people have situations, man.
Okay. All right. Did you want to say anything else, Ms. Harmon?
yes,
No, I would
again,
just like
it's the
thank-
violence it's the brandishing of the gun.
I
that
didn't
is
brandish.
similar to the
That's
state.
hearsay right now.
And thus, we are requesting that you would issue a surety bond in this case and not a signature bond.
Okay. All right. The recommendation at this point is a $4,000 surety bond on the simple assault and $1,000 surety bond on the willful obstruction. I'm going to go with the state's recommendation. So that would be a total of $1,000 surety bond. And there's no drugs, alcohol, or weapons while on bond. And you are to stay away from 1050 White Street. And you're to have no further contact with the victim, Samantha Davison. So I know that Ms. Whitfield, you will relay that to your client since she has gotten up from the chair.
Yeah, I will. Thank you, Your Honor.
All right, thank you.
And Your Honor, I believe the South Annex may be ready for me to speak with Ms. Lopez. So
Okay.
I will, with
Go
your
ahead and do that. Okay. And which cases do you have, Ms. Whitfield? Are you at the beginning, in, middle, or?
towards the end, I have
Your Honor, I can go around Ms. Whitfield's case.
Okay, thank you.
I have positions 6 through 9 next.
Okay. All right, I see it's right on now. Okay, good.
Good
Next.
afternoon, Judge. How are you?
Good afternoon. How are you?
I'm well,
Next,
thank
we
you.
can go to position 4, Mr. Ector.
Okay. All right, this is 22 CR 007954Y. Looks like Xavius Ector. You're charged with 1 count of battery family violence, a 2nd count of battery family violence, and a 3rd count of simple battery family violence, all with the offense date of November the 23rd, 2022. Pretrial?
Yes, 39 cycles, 38 out of Georgia, 1 out of Florida. 2018, 2 theft by shoplifting convictions. 2017, simple assault conviction. 2015, theft by shoplifting conviction. 2013, entering auto and theft by taking conviction. 2012, obstructing or hindering person making emergency telephone call and criminal trespass.
All right.
Would you like for me to continue?
No, that would be farther than 10 years. Is that correct?
Yes.
All right. Anything else? No FTAs or anything?
1 FTA from 2012 and 1 parole violation from 2017, but I wasn't able to see what the parole was for.
Okay. All right. All right. Thank you. All right. Now this is Miss Garner's case. Okay. How are you?
Thank you, Your Honor.
Okay.
Your Honor, this is going to be a felony matter. We'll be seeking to have this transferred. The facts of the instant case are that the victim in this case, Ms. Shannon Bird, admits to looking at the defendant's cell phone, discovered that he had been cheating on her, confronted him after they argued. The defendant punched Ms. Bird in the nose, causing it to swell visibly and to bleed. Later, he took off his belt and struck her thigh with it, and then he wrapped the belt around her neck and strangled her until she could not breathe. And according to her, she felt like she was going to die or would die. They do reside together. They're in a dating relationship. We have spoken with the victim in this case, and again, she confirmed that she felt that she was going to pass out, that she thought she would die, that the defendant told her, "I'm going to kill you, bitch," that she is terrified of him and wants no contact with him whatsoever. In addition, we have found, Your Honor, 4 FTAs in cycles 15, 19, 27, and 31. We found 7 probation violations in cycles 17, 25, 26, 30, 35, 36, and 37. He's got quite some violent offenses for which he was arrested. He pled guilty to terroristic threats, disorderly conduct, and simple assault in 17 CR 018716G. He pled guilty to battery family violence and had a converted disposition, but this was under the name of Xavier M. Printup, and that is 07 CR 324316. and then pled guilty again to obstruction of a 911 call and criminal trespass, again under the name of Xavier M. Printup in 2012. His criminal history indicates that he was indicted in DeKalb County, cruelty to children, third degree, simple battery, and family violence, battery second or subsequent. We do not have a disposition on that yet, as it is in DeKalb County. So at this point, he's also a multi-state offender. Given all of this, we're asking that he be given a bond in the amount of $15,000, good bond on each of the first two counts, and a $5,000 good bond on the third count, that he be required to take an anger awareness class or family violence intervention program, stay away from 569 Ira Street Southwest, and have no contact whatsoever with Shannon Bird, no drugs, alcohol, or weapons.
Ms. Garner, give me your recommendations again on the bond amount.
Yes, Your Honor, the state is asking or seeking a $15,000 good bond on each of the first two counts of battery family violence, and a $5,000 good bond on the third count of simple battery family violence.
All right, thank you. All right, Ms. McLeod.
Yes, Your Honor. My client is 43 years old. While we acknowledge that he does have some history, Your Honor, the bond that the state is asking for, I think, is somewhat unreasonable given what was alleged. My client tells me that actually he was in a relationship with the alleged victim, but this is a situation where he is actually involved with someone else, and she found out and got angry, and she was the one who attacked him because she said she wanted him to go to jail, because at least when he's in jail, she knows where he is. Because she was pretty upset when she found out that he was seeing someone else. And he denies that he battered her, Your Honor. He said that she called the police and she made up the story, and she actually cosmetically altered her face to make it appear that he had battered her, but he denies that he did any such thing, Your Honor. He is employed, he works as a maintenance worker, he tells me, Your Honor. I would ask the court to consider giving him a bond that is more realistic, a bond that he could actually probably be able to make, because the bond which the state has recommended is beyond his means to post, Your Honor. I believe the state is asking for 15,000 good bond, and it sounded almost like they were saying on each count, but I may have been mistaken. But even if it's just a total of 15,000 good bond, that is too much for him, Your Honor, given his means and the facts and the circumstances. I don't know if the alleged victim is on, Your Honor. I wasn't able to get a hold of her. But my understanding is that she did not want to press charges because she had told my client that she had just called the police because she was upset. So I would ask the court to sound for her, because I would like to see if she's on and what she has to say about what happened.
All right, do we have Ms. Shannon Bird on the line?
We do, Your Honor.
Shannon, I see a Shannon. Is that Shannon Bird? Miss Bird, can you hear me? Shannon Bird. All right. Are you Miss Shannon Bird? Okay, waiting for you to unmute yourself with the little red.
He is lying.
Hold on. Let's take it a little more formal than this. Would you like to address the court, Miss Bird?
Yes, I want to address the court. He is lying.
Okay, hold on. If you want to address the court, I'm going to swear you in. Raise your right hand for me. And I need to be able to see. I see your hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth?
Nothing but the truth. He is lying.
Hold on a second. We do have a little bit of decorum that we follow here. So I'm going to ask you a few questions, and the attorneys may also ask you some questions. And so if you are going to affirm that you tell the truth, you can put your hand down for me. All right. Now, what would you like to tell me briefly? And let me ask you this first before you start. Are you in fear of Mr. Ector?
I am.
Okay. And do you all reside together?
Yes.
Presently still? Or
Yes, but he's not allowed back over here. And ma'am, let me tell you something. I'm a student. I'm in school for paralegal. I work with law offices. He cannot tell me nothing right now. He's lying. Everything I said was truth.
Okay.
He
And
trying
so
to get
do you-
himself out of trouble. But at the end of the day, you did what you did, and I'm not going to tolerate it.
Right. Do you have a protective order or something?
No, I didn't get a police report, but the owner said he is not allowed over here, and if he shows up, he's going to go to jail for trespassing.
Okay. Whose name's on the lease there? Or
Mine.
okay,
Mine.
is his name on the lease as well?
No.
But how long has he been residing there with you?
2 months.
Okay. All right. I don't have any other questions. Ms. Gardner, do you have any questions?
Not for the witness, Your Honor. Just if I may reiterate that this did occur on November 23rd of this year on
Yes.
569 Ira Street Southwest in Fulton
Yes,
County.
it did. Yes, it
Okay,
did.
Miss Shannon,
Yes,
this is
ma'am.
not your time to talk, and I want you to be respectful of the court and the process.
I respect you. I'm
Okay,
sorry.
so, yeah, mute yourself until we ask you a question, and then you can unmute and answer. But I don't
Okay.
need you to comment on the prosecutor's.
All right, no problem.
Okay?
I'm sorry.
Thank you. All right, thank you. All right, and so are you saying Ira Street or Iris Street, Ms. Gardner?
That's Ira, IRA Street
Okay.
Southwest.
Okay, I thought so. All right. And anything else? And then I'll see if Ms. McLeod has any cross-examination of the witness.
I do not, Your Honor.
Okay. All right, were you complete or finished, Ms. Gardner? I'm sorry, I didn't mean to cut you off.
Yes, Your Honor. Like I said, this is going to be a felony transfer due to the strangulation and the previous battery family violence conviction.
Okay. All right. At this point for the bond, I'm going to order a surety bond on the first charge of the battery family violence. I will give a $10,000 surety bond. On the second charge, I'll give a $10,000 surety bond, and on the simple battery, I will give a $3,000 surety bond. So that'll be a total of 23,000 surety bond. I will also order no further contact with the victim, Shannon Bird. I will order no drugs, alcohol, or weapons while on bond. As far as this stay away, Miss Shannon, Miss Bird has stated that she resides there and it's in her name. So I'm going to right now order that Mr. Ector stay away from that location of 569 Ira Street. So he is to stay away from that location. Anything else, counsel?
And nothing further, Your Honor.
All right, thank you.
Next, Your Honor, we have position number 1, Mr. Eddie Brown.
This is case number 22 CR 007944E. Eddie Brown, you're charged with 1 count of SB, 2nd count of willful obstruction of a law enforcement officer, and a 3rd count of giving false information to a law enforcement officer, all with the offense date of 11/23/2022. And I want to state that we're not going to sound or mention the exact first charge. We're just going to go by the initials of SD. Go ahead. Pre-trial.
I'm showing 17 cycles, 3 out of Georgia, 2 out of Oregon, 11 out of Louisiana, and 1 out of North Carolina. Last arrest was September 9th of this year for disorderly conduct and simple battery against a police officer. 3 counts. That was with Varner Police Department. I did not see that case in the Odyssey. The last conviction I'm showing is from 2017 for possession of marijuana paraphernalia out of North Carolina. And then I'm showing a 2009 resisting arrest and attempting to elude a police officer out of Oregon, and nothing further.
All right, Ms. Gardner.
Your Honor, this incident occurred at the North Italia restaurant at the Lenox Square Shopping Center at 3393 Peachtree Road on November 23rd of this year. After the defendant acted out at the North Italia restaurant against an employee who was assisting customers there, officers attempted to handcuff him, attempted to fingerprint him, and he resisted both of those efforts by stiffening his arms and stiffening his fingers and refusing to cooperate. He also refused to provide the correct spelling of his name and gave multiple false dates of birth in an effort to try to keep the officers from being able to identify him. The report indicates that he is from North Carolina. The victim also stated that after his conduct at the restaurant, the victim attempted to confront him about this, and the defendant picked up a beer bottle, or he had a pack of beer in his hand and took a bottle and acted as if he was going to hit the victim, Mr. Lima Nunez, or throw the bottle at him. We're asking for a good bond in the amount of $1,000 on each of the 3 counts, that he stay away from Lenox Square Shopping Center altogether and have no drugs, alcohol, or weapons. And again, we're asking for that good bond in part because of his multi-state offender status and the fact that he has no local address.
Give me the victim's name again.
Liman, L-I-M as in Mary, O-N as in Nancy. Last name Nunez, N as in Nancy, U-N as in Nancy, E-Z.
All right, thank you. All right, Ms. Wright.
Yes, Your Honor. Mr. Brown does live in Atlanta. He does work in Atlanta. He does not know the complaining witness at all. When I asked him about what happened, he let me know that he was leaving the store, or the restaurant rather. It was quite crowded. If there was some contact, it was certainly not intentional at all. And in fact, he went and he offered his apologies. But the complaining witness was very, very upset. He called mall security, and he spoke to mall security about the event, or client did rather. And when the police finally came, Mr. Brown let me know that he gave his name, his information to the police, but he does have a stutter, and it gets worse when he's scared and nervous. But he stood there and he waited for them to get the right information. And when it came time to fingerprint him, because I guess they couldn't rightly find him, he tried his best, but he was handcuffed and they couldn't get his fingerprint correctly because the way he was handcuffed. But he wasn't trying to resist anything. He was trying to cooperate to the best of his abilities. There's no way that Mr. Brown could afford a good bond, Your Honor. I am asking for a signature bond for him.
All right, I'm going to order a good bond in the amount of $3,000, $1,000 on each of the charges. I'm going to order a stay away from the Lenox Square Shopping Center or the mall. I'm going to order no further contact with the employee victim, Mr. Limon Nunez. I'm gonna order no drugs, alcohol, or weapons while on bond. And I think that's it, unless there's anything else council wants me to take up.
I believe that's all, Your Honor.
Okay. All right, that will be it, $3,000 surety bond.
Thank you, Your Honor.
Mhm.
Position number 11 next, please.
I'm sorry?
Position number 11 is next.
Okay, 11. This is case number 22 CR 007948J. The Patrinia Varner. You're charged with 1 count of battery family violence. The offense date is 11/21/2022. Pretrial.
I'm showing 9 cycles. Last arrest was in 2007 for theft by receiving stolen property and driving with license suspended or revoked. Last conviction, 2008, for driving while license suspended or revoked, knowingly driving a motor vehicle, suspended, canceled, or revoked registration. 2006, driving while license suspended, and 2003, theft by shoplifting. And nothing further. She's recommended.
Okay.
Yes, Your Honor, this is my case, and this is an incident where it looks like the parties are married and they have children together and probably live together. The defendant was kicking the victim out of the house. The victim in this case is Kelvin Robinson, Kelvin Robinson. She kicked him out of the house because he didn't come home the previous night before, so she was upset about that. And when he refused to leave the house, she began pushing him, and his shirt ripped, and officers were able to observe a visible scratch to his back, hence the charge for battery family violence. We do think that she does represent a danger to the victim. But we are going to recommend in this case a $3,000 surety bond because this is family violence. To have no further contact with the victim, a 1-day anger awareness class, that she would be compelled to stay away from the incident location of 2973 Blunt Street, BLOUNT Street. And no alcohol, drugs, or weapons in this case. Nothing further.
Okay.
Your Honor, my client is 47 years old. She's a mother of 6 adult children, and she also has several grandchildren. Currently, what she does is that she stays at home and she takes care of her grandchildren. That is what she does. And she tells me, Your Honor, that this incident occurred because the gentleman in question was taking her car keys without her permission, and she was just trying to get her keys away from him. And that was when she grabbed him just to get her keys because he was leaving the house with her car. And she was the one who called the police, Your Honor, because she wanted to get her car back. She didn't want him to take her car. And my understanding is that he does not live there, that she actually lives at the property in question with her children and some of her grandchildren. That is my honest, that is her home, Your Honor. But apart from taking care of her grandchildren, she's not employed. She has no significant criminal history, and anything that she has is remote, Your Honor. And as the state said, she is recommended. So I would ask the court to give her a signature bond so she can get home, get out of jail and go back home to her children and her grandchildren. Thank you, Your Honor.
All right. And you're saying that it is her home and that the victim does not reside there?
That was my understanding when I spoke with my client.
They're
That he
married.
came there on the occasion and, you know, he tried to take her car and she wouldn't let him.
Is this a rental or do they own? Does she own it?
My understanding is that it was the rental, Your Honor.
Do we know if both parties' names are on the lease?
No, I believe it's her and children.
I'm sorry. Say that again.
It's her and her children, Your Honor.
That is my only concern about having her to go back there if he still resides there.
She says he's never resided there, Your Honor, that they don't live together. That's what she told me.
And Your Honor, we weren't able to make contact with the victim to confirm that. We would ask an abundance of caution that she would not be allowed to return there.
Sometimes I would order that they can go back with the police escort to determine that.
Okay,
So let me do this. I'm going to give the $3,000 signature bond through pretrial. I'm going to order that Ms. Varner get a police escort in order to return to the home at 2973 Blount Street. And so, Ms. Varner, when you get out, you will have to secure a police escort and arrange for that before you can go back to the property. If you go back to the property with the police escort, which you will have to do, and they determine that there's no clothing items or personal items of Mr. Robinson in the location, then you can stay. If not, then you will have to find somewhere else to live while you're on bond, because I'm ordering that you would have no further contact with Mr. Kelvin Robinson or Roberts. Is it Roberts or Robinson?
Robinson.
Robinson, that you have no further contact with him. So in order to comply with that so that you're not arrested again, you have to make sure that you're obviously not around him. I'm going to order the one-day anger awareness course through pretrial. No drugs, alcohol, or weapons while on bond. But I want to make sure you understand the conditions of going back to the property. Are you clear on that?
Yes, I am.
Ms. Varner, okay.
Yes.
All right, so let's try that. And anything else, counsel, that you want me to take up?
Nothing further from the state.
Nothing further, Your Honor.
All right.
And Your Honor, that concludes my business before the court today. May I be excused?
Yes, enjoy your weekend.
Thank you, Judge.
All right.
Good to you. Thanks.
Uh-huh. All right, deputies, who do we have?
Position number 8 here at the South Annex, Your Honor.
Okay. This is 22 CR 007951G, Michaela Lopez, charged with 1 count of battery on November 22nd, 2022. I think this is the cross defendant case.
Yes.
With what is it, Samuel Tirado?
Correct.
Okay. Pre-trial. Pre-trial.
She has a total of 14 cycles, 1 out of Georgia, 1 out of DC, 7 out of Maryland, and 5 out of Pennsylvania. Last arrest was 2017 for probation violation out of Pennsylvania. I'm showing a 2016 simple assault conviction out of Pennsylvania, and then a 1996 battery conviction out of Maryland, and nothing further.
All right.
Yes, Your Honor, this is our cross-defended case in which the parties were at the incident location of 1315 Sandalwood Drive in Atlanta. They did get into a physical dispute. And she is accused of, during the course of the dispute, or the physical part of the dispute, of burning the victim with a lit cigarette on his lip and punching him. I would like to highlight a little bit more of her history. It did start with a 1996 battery. There was a 1998 assault charge out of Maryland, a 2004 assault charge out of DC, a in the 2000 11 simple assault charge out of Pennsylvania. Then we have the 2016 simple assault charge in Pennsylvania where she did plead guilty, and that was reduced from aggravated assault out of Pennsylvania. So her history is extremely concerning. I do think it shows that she has a likelihood to reoffend. It looks like she's committed violent offenses through multiple states, which is concerning. I think she does represent a danger to the victim. The sheer violence of the attack by taking a lit cigarette and burning somebody in the face is extremely violent. Our recommendation in light of the case facts in her history, the danger to the victim and her likelihood to reoffend is a $5,000 cash bond, no further contact with the victim, Samuel Tirado, Tirado, no alcohol, drugs, or weapons, and to stay away from, the anger awareness one-day class. And Your Honor, I don't remember what we determined about whose property that was, the 1350 Sandalwood Drive, but if she if that's her residence, we wouldn't ask her to stay away from her residence, but if she doesn't reside there, then we would ask that she would stay away from that location.
All right, Ms. Whitfield, this is your case. Are you able to enlighten us a little bit as far as the living arrangements?
I am, Your Honor. And to give you a bit more information briefly, Ms. Lopez does not live at that address. I believe she was in the process of moving her stuff out of that address, so she does have somewhere else she is staying. She would ask for a one-time escort to return to the address with police. She does have some items there that are still at that residence, but she no longer resides there. That's correct.
Thank you. All right, go ahead.
And yes, Your Honor, Ms. Lopez is 54 years old. She has been living in Georgia for the past 6 years in the Atlanta area. She is an electrical technician at Spectrum, and I believe she also assembles laptops, I believe, for various airlines here in Atlanta. She has her GED. She completed some college. Ms. Lopez has been in the process of getting out of a very, what sounds like volatile and escalating violent towards her relationship with Mr. Tirado, who has not wanted her to leave the relationship and has done everything in his power to prevent that. She is the one who called 911 during this this alleged incident after it took place, because she knew that she needed to call for help. She denies this allegation. She denies being the initial aggressor in this particular instance, Your Honor. Like I said, she has been trying to leave. That she has told me, and apparently has documented, called police multiple times on Mr. Tirado in recent weeks. I've advised her on seeking a TPO against him because she is concerned that he knows where she lives. And even though the court cannot impose a stay away against him to her address, because it's not the incident location, she's still very concerned. So, Your Honor, we're asking for a reasonable bond in her case. We're aware of her history. However, it is old. The fact that the state is asking for cash bond for both Ms. Lopez and Mr. Tirado, and I know Your Honor did not grant that, but we'd be asking for a similar bond as Mr. Tirado, perhaps even less, because of her, even though she has some history, it is not nearly as bad as Mr. Tirado's history. So that would be our request at this time, in light of everything I just mentioned.
Okay.
And she has no reason to oppose to stay away from Mr. Tirado again, and no contact with him.
Okay. Ms. Harmon.
Yes, I was just going to point out her history is more recent, and it's the same type of offense throughout these multiple states that she's lived in. It's the same type of violent offense. So that is the basis for the $5,000 cash bond. It's not the same charges that Mr. Tirado has, but it is the same violence throughout the years through multiple states. And that's our basis for that request.
All right, I'm going to order a surety bond, and I'm going to order that surety bond in the amount of $10,000 for the battery charge. I'm going to order to stay away from 1315 Sandalwood Drive. I'm going to order a one-time police escort to return to that location to retrieve any personal items that Ms. Lopez may have. And again, Ms. Lopez, you can't return there until you have arranged to schedule a police escort to go back with you to retrieve any other items that you have there. I'm going to order no further contact with Samuel Tirado. And if he's to have no further contact with you, you're to have no further contact with him. That should be sufficient. And hopefully to keep you safe as well while you're both on bond, to have no further contact. If you do, or he comes to your place, you can obviously call the police because he would be in violation of the bond conditions for him. Okay. And I think no drugs, alcohol, or weapons while you're on bond. Anything else, counsel?
Nothing further.
Okay. All right. That should conclude your case.
Next, we have position number 2, Mr. Marcus Cobb.
This is 22 CR 007943J, Marcus Cobb. You're charged with 1 count of simple battery, family violence, and a 2nd count of simple battery, family violence, both with the offense date of August the 7th, 2022. Pre-trial?
I'm showing 6 cycles. Last arrest was May 4th of 2020 out of Clayton County for possession of marijuana, less than an ounce, possession and use of drug-related objects. That case is dismissed. He has 1 FTA from 2019, and I'm not showing any convictions. He's recommended.
All right. All right, Ms. Gardner.
Thank you, Your Honor. In this case, on August 7th of this year at 2178 Jernigan Drive Southeast, the defendant was living with and in a relationship with Markeisha Thurman. He apparently asked to use Ms. Thurman's car. She said no. So he went into the bedroom and started throwing her clothes from the closet. When she tried to stop him, he threw her onto the bed and then he grabbed her neck and pinned her down by her neck. Ms. Thurman's son intervened, ran next door to call the police. And it was because of that that Ms. Thurman was able to get away from the defendant. And when the, I'll scratch that. We have spoken with Ms. Thurman. She says state that they are on good terms now and is at this point denying any actual strangulation when he held her by her throat. Irregardless or regardless of that fact, there was a battery, at least a simple battery. It was sufficient to cause Ms. Thurman's son to be concerned to run next door and call the police. So we are asking that he be given a good bond in the amount of $2,500 on each of the 2 counts of simple battery. Anger awareness class, that he be ordered to stay away from 2178 Jernigan Drive and have no contact with Markeisha Thurman. Also have no drugs, alcohol, or weapons. And interestingly, cycle 1 on his criminal history indicates a probation violation in addition to the FTA.
All right, that's right.
Yes, Your Honor. When I spoke to my client, our facts were quite a bit different from the state's, which are quite a bit different from Ms. Thurman after I spoke to her. My client was having an argument with Ms. Thurman because she had gone through his phone. They had had an argument about that. Things were escalating, so he left the home to cool down. He went to a friend's house to cool down. After a number of hours, she called him, let him know that she wanted him back in the home, that they should, just talk it out and work it out. And they did. This was back in August. He had no idea that there was warrant out for his arrest until he was pulled over because I guess the tag, something to do with a tag cover was too dark, and that's why the police pulled him over. And they saw that there was a warrant, and that's how we end up here today. I spoke to Ms. Thurman. She let me know that she has been trying to get the state to drop these charges. They live together. They want to stay living together. We would oppose a stay away from the location because they both live there. And if there's going to be a no contact order, we would ask for a no further violent contact. Because these two people are still in a consensual relationship, Your Honor. As far as his criminal history, I don't know if I missed something, but I didn't hear any violent charges. I heard a marijuana charge, and maybe I missed it, but I don't see that there's a reason for there to be a good bond. I am asking for a signature bond. Again, the state or the victim does not want to prosecute this case. She's alleging that it didn't happen quite like the police report. And Mr. Cobb had no idea that this was out there for him until he was arrested.
All right. I'm going to.
And Your Honor,
Go ahead.
Ms. Thurman is on the Zoom. I'm not sure if you want to speak to her.
Yeah, I didn't know that. Oh, I see. Ms. Thurman? Can you turn on your camera?
Yes, ma'am.
I apologize. I didn't see you on the Zoom. Would you like to address the court today?
Yes, I would just like to say that
Hold on a second. I'm going to swear you in. Can you raise your right hand? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, you can put your hand down. What is it you'd like to tell me?
I was just agreeing with Ms. Wright that it didn't happen the way that Ms. Gardner said that it happened, and I wanted to drop the charges against him because we have been staying together for 10 years, and he does stay here. We just got into an argument, and since then, we are on good terms now. That's all.
Do you all have any children together?
No, ma'am.
Okay. All right. And anything else as far as any cross-examination of this witness, Ms. Wright or Ms. Gardner?
No, Your Honor.
Okay.
Nothing further from the state, Your Honor.
Okay. All right. I am going to go ahead and grant the $5,000 signature bond through pretrial. I'm going to order the one-day anger awareness course. I'm going to order no drugs, alcohol, or weapons while on bond. As far as contact, I understand that this incident happened in August and we're now in November. And the parties have been residing together, hopefully without having any other incidents since that time. And I'm going to order no further violent contact with the victim, Markeisha Thurman. And normally, what we do, Ms. Thurman, in these cases is that we order stay away from the location to make sure that you, the victim, are safe and that there won't be any other incidents. I'm feeling, if what I'm hearing is true, that you are safe and you all have been residing together for the last several months without incident. Is that correct?
Yes, ma'am.
Okay. So I'm doing a no further violent contact. I'm not going to order stay away at this point. But with the conditions of your, with the conditions rather of his signature bond, he will have to report to pretrial, take that anger awareness course, and hopefully there will be no other incidents. Okay.
Okay, thank you.
Thank you, Your Honor.
All right.
Your Honor, what's the breakdown? Is it 25 and 25?
Yes, I'm sorry. 25 and 25.
Thank you.
Uh-huh.
You done. Next, we have position number 5, Mr. Matthew Scott Harrison.
This is 22 CR 007946B, Matthew Harrison. You're charged with 1 count of harassing communications. The offense date is November the 18th, 2022. Pretrial.
I'm showing 6 cycles. Last arrest was from March 16, 2016, out of Walton County for driving while license suspended, a DUI, and possession of a schedule to control substance. The driving while license suspended and DUI was a conviction, and the possession of a schedule to control substance was the first offender that was sealed in 2017. Has another 2016 driving while license suspended conviction, a 2013 driving while license suspended conviction, and then a 2010 DUI conviction. And nothing further, he's recommended.
All right. Ms. Gardner.
Yes, Your Honor. On November 18th, 2022, Ms. Sharon Whitehead reported that the defendant had been harassing her by contacting her repeatedly since they broke up, or she broke up with him back in May. She is receiving these contacts at her home at 1303 Walton Way in Roswell. Officers noted when they arrived that Roswell PD had responded previously to another complaint by her regarding the same behavior having occurred previously. She also showed the officer numerous text messages and reported that the defendant began using alternate phone numbers after she blocked all of his other forms of communication from reaching her. We have spoken with her. She said that he has been calling and texting her nonstop, that she is fearful that he may show up at her home, that the defendant was violent during their relationship, that he had pushed her and her 5-year-old daughter. She does not want any contact from the defendant and asked that he be ordered to stay away from her residence. And she is on this Zoom.
Okay.
The state is asking for a good bond in the amount of $2,500. Stay away from 1303 Walton Way in Roswell. No contact with Sharon Whitehead whatsoever in any way, shape, form, or manner. No drugs, alcohol, or weapons.
Okay. All right, PD Wright.
Yes, Your Honor. I spoke to Mr. Harrison. He lives in Georgia. He works in Georgia. He has a good job. He understands that he cannot be reaching out to the complaining witness. The holidays are, I think, harder on some folks than others. I made sure that I communicated with him as strongly as I could, that this is where it needs to end. He let me know that he feels as though he's hit rock bottom. He has no intention of reaching out to her ever again. He is very, very remorseful for his actions. if I understood pretrial and the state correctly, he has no violent cases in his past. The last time he was involved in any way was 6.5 years ago. Your Honor, I'm asking for a surety bond on this case, not a good bond, because he doesn't have a violent criminal history. Yes, Your Honor, that's what we're asking for.
Okay.
Excuse me, Your Honor. I was going to ask for a signature bond if possible.
All right, Mr. Harrison, you should defer to your attorney. I think she meant signature. I think she said surety, but yeah.
I meant signature, Your Honor.
Okay. Yeah, I think I understood. Thank you.
Thank you, Your Honor.
All right, Mr. Harrison, I'm going to grant a $5,000 signature bond through pretrial. I'm going to order that you have no drugs, alcohol, or weapons while on bond. I'm going to order the 1-day anger awareness course through pretrial. And I'm going to order, and I'm sorry, I meant to have Miss Whitehead to see if she wanted to speak before I gave my ruling. So let me apologize and stop there for a second, Miss Whitehead. I'm so sorry. I forgot to ask if you wanted to address the court before I gave my ruling.
No, I had nothing further to say. Thank you, Your Honor.
Okay, all right. Thank you for your time. And I will continue my ruling. $5,000 signature bond through pretrial, 1-day anger awareness course, no drugs, alcohol, or weapons while on bond, no further contact with Sharon Whitehead. And I assume, Mr. Harrison, you do not live at 1303 Walton Way in Roswell?
No, ma'am. I live in Covington.
Okay, so I'm going to order that you stay away from 1303 Walton Way in Roswell. And I think that will be it. Anything else, counsel?
None from me, Your Honor.
Nothing from the state, Your Honor.
All right, that will conclude the ruling of the court.
Thank you, Your Honor.
All right, thank you.
Come on.
Give me 1 second, Your Honor.
Okay.
Callaway, the add-on one, is take some time for him to get to the chair.
Thank you.
Thank you, Deputy.
Happy New Year.
You got it?
Yes, sir.
All right.
Thank you, sir.
Add-on one, Mr. Callaway.
Ms. Grace?
Your Honor?
Yeah, Miss Grace?
Yes, Judge.
Do I have, let me see. Did you send me an add-on? I see it now.
Okay.
I did not see that earlier.
That's okay.
Yeah, hold on 1 second. All right. This is case number 22 CR 007955G. Daryl Callaway, you're charged with 1 count of theft by shoplifting and 1 count of criminal trespass, both with the offense date of 11/24/2022. Pretrial.
He has 109 cycles.
Okay.
Sorry, my baby's screaming. I'm trying. 109 cycles. I'm just gonna tell you how many convictions he has each in the last 10 years. I'm showing 6 criminal trespass convictions since 2012, 5 disorderly conduct convictions since 2012. I'm showing a 2021 simple battery and willful obstruction of a law enforcement officer conviction, a 2019 and 2020 conviction for possession and use of drug-related objects, a 2019, a 2020, and another 2020 theft by shoplifting conviction, a 2014 possession of marijuana less than an ounce conviction, 2013 battery conviction, 2011 and 2013 willful obstruction of a law enforcement officer conviction. I'm showing an open case, theft by shoplifting, 22 CP 214228, and then 1 FTA from 2014. And nothing further.
All right, thank you. ASG Garner.
There might be some confusion on this one, Your Honor. We sent this one requesting a transfer this morning. We did not hear back, and I noticed it was not on the original calendar, so I'm not sure what may have transpired in between then and now. I can let Your Honor know that this is a 4th or subsequent theft by shoplifting. In fact, in his 109 cycles, he had no low pleas, which do count towards convictions under 16.814 in cycle 100, 101, and 103. Not only that, Your Honor, this is for an offense on November 24th, yesterday at the 24-hour food mart. He had been advised just the day before on November 23rd that he was not to return to the 24-hour food mart. He was also giving warnings not to return to the 24-hour food mart on November 21st, November 15th, and November 13th. So he's been adequately warned not to return to the 24-hour food mart, but yet he did return there again. He attempted to conceal a couple of bags of food and a juice beverage. The clerk locked the doors remotely when the clerk noticed that he was attempting to steal again. Then he attempted to hide those items in the back of the store. So given that, Your Honor, this we'll be requesting a transfer on that if that somehow got turned around this morning. But given his extensive history, given his absolute refusal not to reoffend or to return to this place, regardless of how many times he has been told not to return to this place, we're asking for a $2,500 good bond on each of the 2 charges, that he be ordered to stay away from the 24-hour food mart on 5 Cleveland Avenue Southeast, and have no drugs, alcohol, or weapons.
All right. PD Wright.
Yes, Your Honor. This case is very difficult. This happened on Thanksgiving, and we're talking about food here. We're talking about food insecurity. My client lets me know that he doesn't remember being told that he couldn't be there, that he attempted to pay for chips. He remembers them being 2 for $1. The clerk saw him, yelled at him, told him to put the chips down, so he did. And then he tried to walk out the door, but she locked him in. So as far as he remembers, he wasn't trying to steal the chips, he was trying to pay for them. He got kicked out, and before he could leave without the chips, he was trapped in there and the police were called. I understand what the state is talking about with his long history, but there isn't malice in this case. He's hungry and he's, trying to pay for chips on Thanksgiving Day. A good bond will keep him in jail. This isn't someone who is able to just, pay that amount of money to get out. And that is going to mean that he's probably going to plea out so that he can get out of jail. I don't know why felony turned it around. Maybe it's because of the facts of the case, the facts that we're talking about, sending a case up and spending those kinds of resources to turn stealing potato chips into a felony. I am obviously going to ask for a signature bond so that Mr. Callaway can get out of jail, so that he can talk to the public defender's office. He can defend against this case so that he can use our social worker for services. Because I think at the end of the day, Mr. Callaway, more than anything, needs desperately to have connections made with services, Your Honor. Thank you.
All right. I'm going to order a $5,000 good bond, surety bond, 2,500 on each. I'm going to order a stay away from the 24-hour food mart. I'm going to order no drugs, alcohol, or weapons while on bond. And I guess that's all we take up. We don't have a contact, no further contact request against the victim or anyone in the store, do we? I don't think I heard that. Did I miss?
No, Your Honor, just to stay away from the store altogether.
Okay. All right. So if you make bond, Mr. Callaway, believe me, you're not to return to that store at all. And if you do, you'll just be rearrested again. All right.
I speak, ma'am.
I'm sorry.
I speak, ma'am.
Your attorney's probably going to tell you not to, because you may make incriminating statements that are against your interests at this time. This is just a bond hearing. This is not a trial on the facts or allegations of your case to that extent. But this is a bond hearing. You have extensive criminal history. So I've granted you a $5,000 good bond. 10 or 15%, give or take, is needed with the bonding company. So that is what my ruling is at this time. But I want to make sure that you understand that you are to stay away from that food mart, 24-hour food mart on Cleveland Avenue.
It's hard for me, excuse me now. It's hard to understand what's going on. The reason why Mr. McConnell, I don't know Mr. McConnell's last name. Mr. McConnell is the owner of the 24 hours and also across the road, he owns 2 establishments. Mr. Connell pays me $10 every morning for cleaning those properties. I don't understand how they want me to stay away and I clean the properties. And he give me wages for the cleaning. I do mopping sometimes. I do the restroom sometimes. I even stock the cooler sometimes. Not all the time, but I clean all the time. On a daily basis, I receive wages from Mr. McConnell, who owns the place. Mrs. Velveeta, she's one of the associates for Mr. McConnell. Mrs. Velveeta knows that I receive the wages from Mr. McConnell. All the associates do. I was never told by any associate of Mr. McConnell to stay off the property. I was never told that. I was never convicted of shoplifting. I have cases that pending on those, on that thing. I got one on the 1st. I have another on the 6th. Those are the dates. But I have never, ever been convicted of no shoplifting. I'm not a thief, man. I beg, or I panhandle. I even panhandle, man, before I steal. But I'm not, that's not in my blood. That hurts my conscience.
I understand. And this is a bond hearing, and I'm gonna have to cut you off there. I've let you speak a little bit, and your attorney has allowed that as well. You do have 109 cycles, and there are quite a few trespass and theft by shoplifting convictions. So with that in mind, I cannot give you a signature bond, and I will not, but that $5,000 good bond is the lowest that I'm willing to go at this point, because 10 to 12 or 15% of that is not a ton of money, but you know, see what happens. Otherwise, you'll have to come back and be addressed with the court again in December. I think it's December 8th if you don't make bond prior to that time. Okay, so that's going to be the ruling of the court. That's what I'm able to do at this point, given your history.
Man, December, is she going?
No, but I gotta.
December
see
8th,
what you doing.
I have for the 1st and the 6th at Atlanta, for pretrial jail, right?
Mm-hmm.
On signature bond for the same thing.
Right. Well, that's why I'm not going to give you your signature bond. That's why I'm not inclined to give you another.
Let me, can I finish, man? It's an officer. Every arrest is from the same officer. He's harassing me.
Well, but were you in the store taking items that you had not paid for? Don't answer that. That's
Ma'am.
what the allegations are. Let me stop there. Let me stop there. 'Cause this is not a trial.
I never concealed the chips. I never walked out of the door with the chips. I'm at the counter with the chips and they locked the door.
Oh, okay. Well, I tell you what, in order to not incriminate yourself, because the state is here listening, I'm not going to have any more discussions with you about the facts, but that is going to be my ruling on the bond. And if not, you'll have to wait to come back to the next hearing date, which will be December 8th. Okay. All right. Good luck to you.
Your Honor, we have position number 7, Mr. Ishikov.
Okay.
Hello, Your Honor.
This is 22 CR 0079528. Looks like Yuri Ishikov, and I'm sorry if I'm mispronouncing your last name. You're charged with 1 count of battery family violence. The offense date is 11/23/2022. Pre-trial?
I'm showing 5 cycles, 1 out of Georgia, 3 out of New York, and 1 out of South Carolina. I'm showing 3 I'm showing 3 convictions out of New York. A 2015 conviction for attempted armed robbery, a 2012 conviction for robbery, and then a 2006 conviction for larceny. All 3 are out of New York, and nothing further.
All right. ASG Gardner?
It's my case, Your Honor. Your Honor, I believe this is a case between brothers or family members in which the victim in this case, Andrew Dillard, it's DHILLARD, overheard the defendant make a threat to slap his mother in the face. And he stepped up and defended his mother, the victim that is in this case. And the defense became kind of physical between the parties. The victim was placed in a bear-like chokehold by the defendant. And after the incident stopped, the physicality of it, the victim did have a visible scratch to his left forearm and his left hand, and the parties do live together. I do think based on his history, which is violent and concerning, and based on the fact that he made a threat to what I believe is his own mother, we do think that he represents a danger to the victim, the danger to the mom, and a danger to the community in general. Our recommendation in light of the case facts in the history is a $2,500 surety bond, no further contact with the victim, Andrew Dillon, 1-day anger awareness, no alcohol, drugs, or weapons, and to stay away from the incident location of 1030 Astor Place in Roswell, Georgia. Nothing further from the state.
Okay. PD Whitehead.
Yes, Your Honor. So just to correct a couple of things, Mr. Ishikov does not reside there. He actually resides full-time in South Carolina. He was visiting his girlfriend's family. His girlfriend lives here. That is his girlfriend's brother, who was the complaining witness. They do not reside together. It's my understanding that the brother doesn't even live at that address as well. They were just all gathered for Thanksgiving Day. So but he does have ties here to Atlanta in the form of his girlfriend and his girlfriend's sister, mother. They live here, so he does visit quite a bit to come back to Atlanta. Mr. Ishikov was 36 years old. He completed the 12th grade. He is an HVAC technician by trade. However, he's not working now. I believe he was trying to set up his own business, but that fell through, unfortunately, with another party. Your Honor, he does not have any reason to contact Mr. Dillon moving forward. We would not oppose a no contact. We would not oppose a stay away, but he doesn't live at Mr. Dillon does not live at that address. So, and Mr. Ishikov does not live there. So we'd be asking for as reasonable bond as possible. His criminal history does not involve this particular type of offense, Your Honor. So considering that, we'd ask for no more than a $1,000 good bond on this case, in light of the lack of relationship between the two parties.
Okay. And no witness, correct? Making sure. All right. I'm going to order the $2,500 surety bond. I'm going to order that there be no drugs, alcohol, or weapons while on bond. And I'll just go ahead out an abundance of caution. Order stay away from 1030 Astor Place. And I'm going to order no further contact with the victim. And that victim's name again?
His name is Andrew Dillon, I believe. It's DHILLON. It's the last name.
Okay. And no further contact with the victim, Andrew Dillon. All right. Anything else, counsel?
Nothing further.
No, Your Honor. Thank you.
Next, Your Honor, we have position number 9, Mr. Paul, Gene Paul.
Just 22 CR 007950F. Mr. Gene Paul, you're charged at 1 count of battery, family violence. The offense date is December 25th, 2021. Pre-trial.
I'm showing 9 cycles, 3 out of Georgia, 2 with the U.S. Secret Service, and 4 out of Florida. on a 2017 conviction for bank fraud and attempting and conspiracy to commit fraud with the Secret Service, and then a 2012 conviction for resisting arrest and DUI out of Florida, and nothing further.
All right. ASG Harmon?
Yes, Your Honor, this is my case. This case involves parents of the same child. And I do believe the victim is on the chat. Her name is Megan Tooney, T-O for Tony, T-O-N-E-Y. The defendant and the victim were in an argument over their then five-month child having COVID. Some argument ensued about how the baby sustained COVID. She then threw a can of Lysol across the room. And the defendant became enraged and he started slapping and punching Miss Tony while she was holding her baby. And the officers did observe a visible injury to Miss Tony. She did have some bruising as a result of the incident. Your Honor, our recommendation in light of the fact that he does represent a danger to the victim, a danger to the child, is that he would have a $5,000 surety bond to stay away from the incident location, 3380 Peachtree Road, apartment 2106. No further contact with the victim, Megan Tony. No alcohol, drugs, or weapons, and the one-day anger awareness. I do recognize, Your Honor, that this incident was some time ago. However, it's still a concerning incident that he would become so enraged that he would physically attack this young woman while she was holding their shared child. It's very concerning for the state. So that's our recommendation in this matter.
All right. And PD Whitfield?
Yes, Your Honor. Mr. Paul is 31 years old. He shares a 1-year-old with Miss Tony. He's lived in Atlanta for the past 10 years, has friends in town, previous employers who can provide support for him. He's a high school graduate and works currently in real estate development. He owns his own business doing that. I had a chance to speak with Miss Tony earlier. It's my understanding that she wants to drop these charges. I know if Your Honor would like to address her, of course, but it's my understanding that she wants contact, doesn't want him to stay away. We would oppose a stay away in this case. They still live together. They co-parent together quite well. It has been a year with no other allegations of any sort of violent or any other incidents related to this. So we'd be requesting as reasonable a bond as possible, as low a bond as possible, no more than $1,000 for Mr. Paul.
All right. And Miss Tony, would you like to address the court today?
I would. Are you able to hear me?
Yes. Can you raise your right hand for me so I can swear you in first? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, put your hand down. What would you like to tell the court today?
So the arrest warrant actually came to a surprise because I had spoken with a detective. I believe the date was like January 13. We talked about everything. We determined that everything was good and that this situation was going to be left alone. He told me that I needed to answer a text message confirming his identity. He said, and I asked him if I answer this message, like what's really going to happen? He said, oh, nothing's going to happen. Just answer it so I can close out the case. So I did answer that text message. We weren't aware that he had a warrant for it. He would have immediately, it wouldn't be an outstanding warrant if he knew that he had it. He would have turned himself in for sure. Also, I work 6 nights a week. He is a full-time parent to our daughter. He is the one who puts her to sleep. So as you can imagine, the last few nights have been a nightmare for me because I'm not the one who puts her to sleep. So they also do swim class together every week. And that's another thing that I'm a bystander for. So he does take care of his daughter. And like, I would love for him to come home. I want him home, but she needs him home. And he is my only family here. I'm from Connecticut. I don't have family here. So yesterday it was just me and her. And I never wanted it to go this far. And I had already voiced that.
Okay. And are you in fear of Mr. Paul?
No, we have never had any other incident besides that one.
All right. Thank you for your time, for getting on, and I will consider what you stated. What I'm going to do is I'm going to order a surety bond, and I'm going to make that surety bond in the amount of the $5,000, given his history. And with that $5,000 surety bond, I'm going to order no further violent contact with the victim, Megan Tony. No drugs, alcohol, or weapons while on bond. And as far as the living arrangements, Ms. Tony, is this a leased apartment that you all have together?
Mm-hmm.
And both names on the lease?
No, just mine.
Just yours?
Mm-hmm.
I do understand the argument or your point that this has been almost over a year ago.
Yeah.
I'm hoping it's stated that you've not had any incidents since then.
No.
So I'm going to do the surety bond, but I'm going to order no further violent contact with you, and I won't enter the stay away at this time.
Thank you.
All right. Good luck to you all.
Thank you.
All right. Anything else, counsel?
Nothing further.
All right.
All right, thank you.
Mhm.
Next, we have position number 6, Mr. Eric Hughes. Position 6.
Okay. This is case number 22 CR 007953C, Eric Hughes. You're charged with one count of simple assault. The offense date is November the 8th, 2022. Pre-trial.
He has 10 cycles. Last arrest was September 7th of this year for a probation violation. He had a conviction earlier this year for obtaining unlawful entry into MARTA and criminal trespass. He has 2 open cases. The first is for 2 counts of aggravated assault. That case number is 22 CP 214218. And the second is for simple assault. That case number is 22 CR 007953C. And nothing further.
All right. ASG Harmon.
Yes, Your Honor. This is another incident that has taken place involving Mr. Hughes and MARTA passengers. He was at the Sandy Springs MARTA station where he encountered the victim in this case. Her name is Callaway. That's CALAURA. Her last name is Smith. This was a stranger to Mr. Hughes, excuse me. He started hurling insults at her, calling her fat, telling her that nobody would want to have sleep with her, and that no one could protect her. He chased her throughout the MARTA and throughout the MARTA station, and basically terrorized her and harassed her for no apparent reason. The concerning part of this history, Your Honor, is that this happened on, and in addition to this incident, he had the disorderly conduct on the MARTA station at the MARTA from 11/17. And then he got the 2 open aggravated assaults. Those also occurred at MARTA Station. That was at the North Springs Station, where he pulled out a box cutter and was threatening passengers with the box cutter. Again, strangers to him, for absolutely no apparent reason. You heard Preacher tell you about the earlier criminal trespass conviction in May of 2022, and that was on MARTA. He started some of his history in 2016 with a simple battery conviction. He had a terroristic threat out of Cobb in June of 2022 as well. So of his 10 cycles, it looks like half of them are violent and most are occurring on MARTA. We think that he's a clear danger to the victim in this case, Ms. Smith, and a clear danger to the community. Our recommendation in light of that is a $7,500 surety bond, no further contact with the victim, Kalora Smith, to stay away from all MARTA property, no alcohol, drugs, or weapons. Nothing further.
Okay. All right, PD Whitfield.
Yes, Your Honor, thank you. Mr. Hughes's bond is actually currently set on this particular charge at $10,000 surety. We'd be asking Your Honor to consider lowering that to a reasonable amount, Your Honor. Mr. Hughes is 33 years old. He has lived in Atlanta almost all of his life since he was a child. His father still lives in town. He completed some college, Your Honor's high school graduate, completed some college. He's been working as at a moving company, sort of sporadically. It's been a pretty tough year for moving. Sounds like very inconsistent hours, Your Honor. So considering this, I've spoken to him about MARTA's own likely trespassing warning against him, and he knows to stay off that. He does plan to appeal it because he uses MARTA for work to get to work. But Your Honor, we have no reason to oppose a no contact provision with Ms. Smith. We would request, and I know considering his history, it might be a long shot, but we would just request avoiding or staying away from the Sandy Springs station in particular from MARTA. So that was, yes, we just request that you lower it by any amount you see fit, Your Honor.
And I'm sorry, Your Honor, I missed the $10,000 surety bond. I am not seeking to lower it. I think $10,000 is appropriate. I know it says 7,500, but I did actually write in my notes 10,000. But I would request that you issue the $10,000 surety bond because of his history, not only with violence, but violence on MARTA in particular. I don't think that he belongs on MARTA. I don't think he respects the rules of MARTA. I don't think that he respects when he's told to stay away. Obviously, he wouldn't have a criminal trespass violation if that was the case. So I do think that he needs to stay off of MARTA and find another way to work, like rideshare, Lyft, Uber, or some other means, because he's not safe for the passengers on MARTA. He's too risky for MARTA, and he's too risky for this victim. So we do think a $10,000 surety bond is more appropriate in this case. Thank you.
Okay. I think that what I'll do with this case is to given his history as well as the assault on a stranger victim, I'm going to leave the bond at the $10,000 surety bond. I'm going to order again to stay away from all MARTA locations. Still get around by Uber, ride shares, or things of that nature. Just don't even go use MARTA at all. And a no further contact with the victim, Kalora Smith. And again, that's to stay away from all MARTA. If you make bond, Mr. Hughes, you're not to use MARTA. Trains or buses, nothing for your transportation. You'll have to find some other means. But I'm going to leave that bond at $10,000 surety owe, and no drugs, alcohol, or weapons while on bond. All right, that should conclude this case.
That's about that. Yeah, a lot of this, I'm trying not to discuss the case. A lot of it's been fabricated. I didn't know that I didn't have rights to the van. All I did was hear someone describe what I was wearing. And I felt like I was being sexual harassed. So I said,
Well, hold on. I'm sorry. I'm sorry.
Go ahead. Never mind.
I just want to make it clear for the record that I've advised you on your Fifth Amendment rights to remain silent and not testify against yourself. I just want to make it clear, but I would advise that you not speak about the case, but if you want to.
There's nothing that I'm going to be able to do about any of the particular facts at this point. I am just giving a determination more so based on your history and the allegations as to whether or not you would be a risk in not returning to court. But I also want to make sure that victims are safe while you're on bond. So that is why I'm ordering so that there will be no other incidents and no other victims, is that you not ride MARTA while you're on bond.
No, I know what I can do.
I don't want to discuss any of the other allegations or facts that are not before me that really would not necessarily have any bearing upon my ruling at this time regarding bond.
Yes, I just had a question. Let me just talk for a second.
Okay.
Let's see what's the surety bond? Is that go to the bond company?
Go to a bonding company and they'll require anywhere from 10 to 15%, not sure.
So if I can't make that bond,
basis. I'm sorry?
I'm not even make that bond. I don't have anybody to pay for it. I can't pay the bond myself though. What are my options?
To reach out to some family and friends to see if they can do it for you. Well, you'll come back up on December the 8th, and then your case will be reevaluated by the court at that time.
I just got a $30,000 bond of your calendar.
I'm sorry, say that again?
He went to felony.
I went to felony and got a $30,000 calendar.
Oh, so you have a $30,000 felony?
So it's like, I'm not gonna be able to get out. I'm trying to see what are my options. But how long do I have to sit for a $30,000 if I can't make that bond?
Oh, I can't talk to you about the felony. That's not me. That's the other court. That's Superior Court. So all I'm addressing
Come and talk to me? Well, when will the attorney come and talk to me? 7 days?
No, I don't know if Ms. Whitfield is aware of who and when and where your attorney will come and talk to you. She could maybe get a message to them, but I don't know who your attorney is in the felony matter.
I'm discussing this court right now.
Oh, Ms. Whitfield, he wants to know when will you come and see him again?
Well, you will be on, it sounds like you'll be reset to the SAP calendar for this case, which is December 8th. So we actually have another attorney who might be handling that calendar. So somebody will come talk with you before December 8th. In the next 2 weeks or so.
All right. All right, that will conclude this case. Thank you, Mr. Hughes.
Thank you.
Okay.
It's 2 weeks. Okay, perfect.
Thank you.
Your Honor, Mr. Dupree, who's actually position number 3, I think Ms. Wright did a waiver on him.
Okay.
Your Honor, I did, but he wasn't in a place where he could really talk to me at all. And I don't have any information on him. So I'd ask that he be reset. I don't have any information to share with the court in terms of bond factors.
Okay.
Yeah, Ms. Wright, but even if we reset him to tomorrow, it's going to probably be the same exact thing. He has some severe MH issues.
Okay.
He's not talking, he's just waving his hands in the air and looking up at the ceiling. That's all I get. And he's on a lockdown zone, Your Honor, because he did something else while he was in jail.
Your Honor, and I have let my supervisor who handles competency know about Mr. Dupree and possible mental health issues. I just don't feel comfortable having a hearing with a client that I haven't been able to speak to.
Right.
And also, Ms. Wright, excuse me, we need you to send over that waiver.
Well, if we're not going forward, I don't know the waiver is relevant. But it needs to be, I don't want to have a Riverside issue. It needs to be reset, or you can send me an order for an MH evaluation and I'll sign that.
I will
And
do that.
accept the waiver. Yeah, you send me that, or send that to Ms. Grace. Melissa.Grace, send that request for MH eval.
Excuse me, Judge, it would actually be Miss Champion. I'm hosting. It will be
Oh, sorry about
April,
that.
April.Champion. Thank you.
Yeah, sorry about that.
I can try to get him interviewed again tomorrow, Your Honor, but I'm pretty sure 100% that he's gonna do the same exact thing.
Right. Well, if I sign this order today, yeah, if I sign this order today for the MH eval, it'll be under that. And see how quick we can get him evaluated, and then they can move him over to the competency calendar once they get this. So we'll do the MH eval order today. And did Ms. Wright did you already file the waiver?
I sent it to Mr. Michael Jordan.
Okay.
But I will gladly send over an inmate evaluation form as well.
Okay. Okay. All right, we'll do that. So Ms. Champion, do I still need to reset it for tomorrow, or we'll just wait?
Unfortunately, Ms. Champion's having issues. She's not feeling well with her throat, Judge.
Okay.
So what you want me to ask her, April?
Ask her, do we still need to reset it for tomorrow?
It needs to be reset for tomorrow, Judge.
Okay, let's do that, and we'll have as long as we have the two orders, we'll know where we're going at that point for tomorrow.
Okay.
See if you can speak with Mr. Howard to see if there's a possibility of anything else being done. I think Judge Williams will be here tomorrow. I will let her know about it. But once I sign this order for today, that may be sufficient to not bring him tomorrow anyway, but let's see what he thinks we should do as well. And then we'll kind of go from there and let Judge Williams know tomorrow how to handle it.
Yes,
Okay.
ma'am.
Okay.
I'll be here tomorrow, Your Honor.
Oh, you will? Oh, good. Okay, so you'll remember. Good. Okay.
Okay.
Anything else that we have? Or is that everybody?
That's everybody, Your Honor.
Okay, good. Let you go enjoy the rest of your weekend for what you have of it. All right. Thank you. All right, bye. Oh, well, are we reconciling everybody? I'm sorry. Miss Grace, are we reconciling, or Miss Champion?
Yes, I am.
Oh, you
ready?
Okay, yes, ma'am.
We're gonna start with the add-on calendar. Position number 1, $5,000 good bond. Position number 2 on the regular calendar is a $3,000 good bond. Position number 2 is a $5,000 pretrial
Hold on, you said
bond.
2. You said 2 twice. You mean 1 and then 2?
I'm sorry, yes, 1 and then. Now position 2, Marcus Cobb, $5,000 pretrial bond. Position 3 is reset for 11/26 SCA calendar. Position number 4 is a $23,000 good bond. Position number 5 is a $5,000 pretrial bond. Position number 6 is a $10,000 good bond. Position number 7 is a $2,500 good bond. Position number 8 is a $10,000 good bond. Position number 9 is a $5,000 good bond. Position number 10 is an $8,500 good bond. Position number 11 is a $3,000 pretrial bond. Position number 12 is a $5,000 good bond.
Okay. That will do it. All right. Thank you, everyone. Have a good afternoon. Good rest of your weekend. All right. Take care.
Bye-bye, Judge.
Bye-bye.